grazie ai penalisti europei per essersi riuniti oggi a Roma, per l'Ordine degli Avvocati di Roma e per la famiglia forense romana. È un onore ospitare questa riunione prestigiosa di colleghi penalisti ed è anche un'opportunità per noi avvocati romani venire a contatto con colleghi di tale qualità e di questa qualità e di questa importanza. Ci auguriamo di ospitare anche in futuro manifestazioni analoghe. So che questa mattina siete stati presso il nostro Consiglio dell'Ordine all'interno del Palazzo di Giustizia di Roma, spero che vi siate trovati al meglio. Ieri ha giurato qui a Roma il nuovo procuratore generale Antonio Mura, che è un magistrato di lunga esperienza e che è un magistrato che ha caratterizzato la sua carriera con la conoscenza del diritto eurounitario e con la partecipazione a tutte le iniziative europee, uno dei massimi magistrati esperti di diritto europeo e di diritto penale europeo, e quindi credo che la sua nomina a Roma sia anche da questo punto di vista un segnale che la stessa magistratura ha voluto dare per l'apertura e per avere a Roma una prospettiva internazionale e quantomeno euro-unitaria del diritto e una visione più ampia delle nostre realtà. Vi auguro una buona permanenza, sono convinto che saranno dei lavori interessanti. Purtroppo la pandemia ci ha impedito di farli all'interno di una cornice che prevedesse una partecipazione maggiore di pubblico, ma ci riserviamo di ospitarvi nuovamente non appena sarà possibile, non appena le condizioni sanitarie renderanno più semplice organizzare un altro evento di questo tipo. Grazie davvero e benvenuti a Roma.
Dear Mr. President, dear colleagues, ladies and gentlemen, I am honored to open this Congress held here in Rome. The Union of Italian Criminal Chambers, that I represent as its president, is an association founded in 1982, counting 131 local associations and over 8,000 members practicing criminal law. Its aim is to promote the knowledge, divulgation, and protection of the fundamental values of criminal law and of a fair and equal trial, a goal we pursue by developing several studies and implementing cultural and political initiatives for the growth of the criminal justice system. In addition, Union of the Italian Criminal Chambers gives great importance to the role of lawyers in promoting and protecting fundamental human rights. For all these reasons, there is a strong commonality of interests between us and ECBA. And because of that, it is strategically important for us and ECBA to share experiences, increase our political role, strengthen our activities, and strive for a better future for criminal justice, a challenge we need to take on with balance, while never sacrificing the effective right of defense that belongs to every citizen that faces a trial. My warmest wishes and support for a successful conference. Thank you.
Thank you so much. Signor Presidente, onorevoli colleghi, prima di parlare inglese vorrei dire qualche parola nella lingua di Dante. Perché in italiano? Perché siamo in Italia, certo, ma è per esprimervi dal profondo del cuore la mia gratitudine e quella di tutti i congressisti qui presenti. Grazie mille perché, come tutti sanno, non è stato facile incontrarsi nella vostra bella città di Roma. La crisi della Covid-19 ha colpito le nostre economie, la nostra capacità di andare e venire a volte ha causato il lutto delle nostre famiglie. Ci avete incoraggiati a mantenere la nostra conferenza d'autunno e avete fatto del vostro meglio per renderla interessante e piacevole. Atene e Roma hanno inventato la democrazia e il diritto e oggi ne abbiamo bisogno. È Roma che ci convoca oggi. Non è un caso. Non esiste il caso. Non per niente stiamo tenendo la nostra conferenza d'autunno in questo periodo difficile in questa città che è la culla del diritto. Grazie a voi. Grazie a voi. Domani parleremo di attualità, in particolare dell'istituzione della Procura europea e della Lega di fronte alla pandemia di Covid. Grazie a voi. Beneficeremo di condizioni di lavoro ideali. Grazie a voi. Avremo i migliori altoparlanti della penisola Italia. Peccato per gli altri. Grazie agli organizzatori, all'ordine degli avvocati di Roma e all'associazione di avvocati e penalisti di Italia. Grazie a tutti voi.
And then finish.
Yes, and then finish, for sure. 2, 3, 4, 5 sentences, not more than that. I have spoken in Italian because I thought it was the best way to express our heartfelt gratitude. A special gratitude because it was not easy to organize our conference this year. We have canceled our spring conference and we have hesitated, remember, to maintain our autumn appointment. COVID has spoiled the economy of our countries, disorganized our job, reduced our capacity to travel. The virus has plunged our families into mourning and made us sick. Fortunately, I am a bit stubborn, and fortunately, Italian colleagues were there. Thank you, Amedeo. Thank you, Amedeo. Thank you, Mr. President. Thank you, Mr. President. Our conference will be a very good conference.
This conference is a special conference due to health condition and also because we are going to celebrate one of our members who unfortunately have disappeared this year. I am moved, but I am very proud of you, because you are here, because you are present, because clearly you did your work during the confinement, during COVID period. You were at the police station, you were at the hearings, you were with your clients, and today you are here, and thank you very much. We have the pleasure to welcome preeminent speakers and also a representative of the Rome Bar. Madam, you have the floor.
On behalf of the Rome Bar Association, I have the pleasure and the honor of welcoming you, distinguished colleagues and esteemed guests, to this very important conference that confirms the fundamental role held by the European Criminal Bar Association. The topic of the conference could not be more current. The role played by European Prosecutor and the College of the EU Public Prosecutor Office will be of crucial importance for the development of European criminal law. The creation of the UPPO marks a fundamental development in the fight against crimes affecting the EU's budget. It is also an important step towards creating a common criminal justice area in the European Union as a whole. While waiting for the European Public Prosecutor Office to become operational, the Rome Bar Association wants to express its deep satisfaction for the establishment of such an important office, and personally, as president of ADG Italian, Association of Italian Women Jurists for Equal Opportunity, I express my highest satisfaction for the appointment of a female chief prosecutor, such as the distinguished Laura Codrupa Covesi. I would like to thank you, the European Criminal Bar Association, for this invitation. I leave you to the distinguished speakers. Thank you.
Thank you for your kind word, Madame Conti. And we also have the privilege to invite by video conference the head of Cabinet of Ministry of Justice, Raffaele Piccirillo. Is it? Okay.
Mi ascoltate?
Good morning.
Good morning. Allora io intervengo per portare il saluto del Ministro della Giustizia a questa iniziativa del European Criminal Justice, e esprimendo un particolare apprezzamento per la scelta del tema, che è partito dalla prossimo aro del procuratore europeo, del European Public Prosecutor, affronta il tema delle videoconferenze e di altri nodi, come quello appunto del nis in idem, connessi sicuramente alla partenza di questa istituzione. Trovo in generale molto importante che i temi della cooperazione internazionale siano affrontati nella prospettiva dei diritti della difesa, perché è mia convinzione che in questa materia ci sia stato un po' il monopolio della prospettiva investigativa e della efficienza punitiva, e si sia un po' trascurato il profilo dei diritti della difesa. Io sono convinto che in realtà la cooperazione internazionale può essere un momento di fertilizzazione, per così dire, delle garanzie. E ho molto apprezzato il vostro documento del 6 settembre sul tema delle videoconferenze, soprattutto per il realismo e per l'appropriatezza di alcune distinzioni che vengono operate tra i diversi usi che si possono fare della videoconferenza. In questa chiave mi piace sottolineare un aspetto che condivido profondamente, che condivido profondamente, che è quello della videoconferenza nelle indagini e nei procedimenti cross-border, dove in effetti la videoconferenza si può presentare come un'opzione preferibile sul piano delle garanzie a altri modi più tradizionali della raccolta della prova al di fuori dei confini nazionali. Semplicemente solo che si consideri il fatto che la prova raccolta attraverso la videoconferenza viene gestita secondo le regole dello Stato che la deve utilizzare nel processo, tale per cui è superato il modello tradizionale della rogatoria, come delega in bianco conferita dalle autorità di un Stato ad un altro Stato. Nella prospettiva italiana questo significa, per esempio, che la raccolta della prova dichiarativa avverrà nelle forme della cross examination, che come sapete è un standard più elevato dello standard minimo richiesto anche dalla Corte europea dei diritti dell'uomo. E nello stesso tempo io trovo importante nel nostro documento la sottolineatura dell'importanza delle tecnologie, della qualità delle tecnologie, che individua come la qualità del videocollegamento sia una condizione di legittimità dell'uso di questo metodo di prova. Io credo che quando la Convenzione di Bruxelles del 2000 o il protocollo addizionale del 2001 individuano tra i limiti operativi della conferenza quello della disponibilità di una tecnologia e dicono che quindi la videoconferenza si può fare a condizione che lo Stato richiesto disponga delle tecnologie necessarie per realizzarla. Questa condizione deve essere oggi interpretata in chiave di garanzia, cioè una qualche tecnologia capace di garantire il videocollegamento è ormai reperibile o disponibile dappertutto. Quello che è importante, queste tecnologie garantiscono il nostro il realismo partecipativo, cioè una condizione il più possibile, diciamo, simile a quella che si realizza con la presenza dell'imputato e della fonte di prova, fonte dichiarativa dell'aula d'udienza. Quindi ritengo che i vostri principi che enunciate nel documento del 6 settembre rappresentino una sorta di attualizzazione e anche di modernizzazione, vogliamo, di quelle regole tradizionali sulla videoconferenza che rinveniamo nei documenti che ho citato, appunto la Convenzione di Bruxelles, il protocollo addizionale e di recente anche l'ordine a direttiva sull'ordine europeo. C'è poche parole da spendere sul tema della istituzione del prosecutor europeo. Il Ministero della Giustizia è impegnato su un'opera di adattamento del sistema italiano a questo nuovo strumento. È un'opera non banale, non semplice, stiamo compiendo delle scelte delicate. Le difficoltà, alcune difficoltà sono connesse, diciamo, al principio, come dire, dell'indipendenza del pubblico ministero, che evidentemente trova qualche difficoltà a connettersi con le previsioni del regolamento che impongono al procuratore europeo delegato di attenersi alle direttive che riceve dalle Camere permanenti, cosa che, diciamo, è abbastanza in contraddizione con la tradizione italiana e che quindi va in qualche modo, diciamo, coniugando le peculiarità del nostro sistema. E poi c'è un altro tema che è quello della individuazione del numero dei procuratori europei delegati. Su questo tema noi riceviamo delle sollecitazioni per indicazioni, come dire, che in questo momento ci paiono piuttosto espansive e che nascono da una valutazione dei carichi di lavoro che evidentemente non è esattamente quella a cui sono abituati gli inquirenti italiani, anche in ragione del principio di obbligatorietà dell'azione penale, che evidentemente non ci accomuna a molti altri paesi che diciamo che hanno sostenuto questo strumento, agli altri 22 paesi presso le cui autorità giudiziarie questo strumento troverà attuazione. Quindi concludo rinnovandoli il saluto mio e del Ministro della Giustizia, auspicando il successo di questi lavori che avete iniziato ieri, auspicando anche di poterne ricevere un resoconto e dei risultati che avremo modo e cercheremo di valorizzare nella nostra azione anche sul piano legislativo, in questa azione che è intesa, tra le altre cose, anche a individuare quali parti degli accorgimenti che abbiamo dovuto adottare per fronteggiare l'emergenza della pandemia meritano di essere stabilizzati nel sistema in favore, diciamo, di un'accelerazione del processo, e quali parti invece che entrano in frizione con garanzie fondamentali devono considerarsi come una esperienza circoscritta alla eccezionalità di quel mondo. Grazie.
Thank you so much. Thank you for your welcome speech. And now I propose you to begin our conference with a tribute for Scott Crosby, our colleague. I prefer the French name, hommage à Scott Crosby. That's the same, but I prefer. And for that, I would like to invite Nicolas Caestrini, Alex Tinsley, and Alexis Agnostakis, because these colleagues were, of course, like many of us, close friends of Scott, but they have worked with him on special cases or on special areas, and they clearly want to make a contribution. Please, Nicola.
Grazie Presidente. Ciao Laura. Dear Scott, I'm sorry for those who didn't have the chance to meet you, personally and professionally. I'm sorry for us, because with you, we lost an engaged and brilliant lawyer and thinker. And this in times where such persons are needed more than ever. I meet Scott, I meet you in a personal situation where I was endangered due to death threats spread out by an Italian politician. It didn't take you 1 minute to stand up for me and to write to the Italian government and to the European Parliament asking for more respect for the role of us defense lawyers. What I learned from you, Scott, is that we should not be worried for speaking out and standing up for those who have no voices, which is the essence of our profession. Thank you, Scott.
Thank you very much. Well, the strongest memory that I have from Scott is when he decided, on behalf of the Human Rights Committee, to go to Turkey on the mission to support the impaired colleagues there. There were Turkish lawyers who were on trial for political reasons, of course, just because they dared to defend political dissidents of the government. So, and you can understand it's very dangerous to be right when the government is wrong. But he insisted on going despite the fact that many had advised him not to do so. I mean, the atmosphere there in the trial was intense, polarized, and there was no guarantee for his safety. As I told you, many advised him not to go, his wife included, myself, but he insisted on going with the aim of giving support. Laura can understand that, and I can tell you, he was so passionate and he was so brave that everyone was talking about him on that day. But the important thing is not what he did, but how he did it. With strong determination, but at the same time with a sense of service. I mean, no bragging, no complaining. That was Scott's spirit, and that's why the task to replace Scott, I think it's rather a mission impossible. I mean, I won't even try to do that, and nobody can do that. I think only our collective, let's say, strength can do that, because the Human Rights Committee, which is his inspiration, his creation, and we followed his lead, and we didn't regret that. But the Human Rights Committee is not me, it's not you, not everybody else. It's everybody of us who wants his voice heard about human rights and fair trial. So please engage in the Human Rights Committee. Please engage in our activities to vindicate Scott's vision and thoughts. And if I can reverse Martin Luther King's quote and add a positive spin to it, justice somewhere is a chance for justice everywhere. Don't forget what happened in Turkey with our Turkish lawyer, a Turkish colleague who died in hunger strike, Emrik Tobruk. Do not forget that, and let it be that she exchanged her life for fair trial. So I call you in the memory of Scott, not to make human rights great again, but I don't support these ideas, these slogans and these politicians, but let's make human rights even better for Scott's vision and for Scott's memory. Thank you very much.
There's a common theme emerging in these speeches, and I can only add to it. I had the privilege of working Scott a lot in the couple of years before he passed away. He approached me to work on a case to do with specialty. Is a person who's extradited for one thing and then detained for another arbitrarily detained? Of course, the answer to this question is yes, but somehow the international courts have not recognized it. And there's a reason for that, is because no one has really pushed the point enough. And here was Scott trying to do exactly that. When I first saw it, I was taken aback, but suddenly, having spoken with him, I was utterly convinced of it. And of course, what was driving him here is the same thing that drives him in everything, which was a belief in the dignity of the individual in conflict with the state. And the sort of way in which his energy rubs off on other people is not just me, it's in everything he did. You can tell from what Alexis just said, the effect that he had on the European Criminal Bar Association's Human Rights Committee, but it went much more broadly. I remember him telling me about the ceremony where he became a Brussels lawyer. As you know, he was originally from Scotland, an advocate in Scotland, and had practiced under the European Lawyers Directive in Brussels for many years. And after the United Kingdom voted to leave the European Union, he became an out-and-out Belgian lawyer. This involves a ceremony along with all the new novice lawyers who've just finished law school starting out in the world of law. Each of them stands in front of the judge and takes the oath and goes, je le jure, I swear. Now Scott, a man who's challenged international sanctions in front of the European courts, was suddenly amongst all these youngsters, and he said, I'm going to show them how it's done. So he stood up, tall as he was, and really shouted it out to the president of the Court of Cassation in the back, je le jure. And then everybody who followed, I imagine, felt emboldened in what they were doing and that sense of vocation. And there you have Scott in a nutshell, speaking the language of Europe, achieving impact in just a few words, which anyone who's ever received an email from him knows was his manner, reaffirming his commitment to European human rights and the rule of law at a time where they're under threat in this part of the world. All of those things in that moment speak to me of the person I knew, and doing all of that with a sense of humor and a smile on his face. And so to his family who are present with us by video and those who are present here today, all I can say is that je le jure as well, I will do what I can to carry on the work that Scott started under the leadership of Alexis in the Human Rights Committee, and I hope we all can too. Thank you.
Grazie, thank you very much. Forgive me if my voice trembled a little bit. I'm really very moved by the very nice words that Scott's colleagues said about him. But I can tell you and assure that it's exactly what Scott was. They described him very well. And Scott was very, very much committed to this association, and especially to the Committee on Human Rights. And until a few days before he died, he was still working on things, on this committee and on his new journal on European criminal law. I would like to thank people who wrote to me at the moment of his death, and I apologize if I didn't answer. He was too much for me at that time. And I really hope, now that I go back home, to write to everybody personally. And my wish to Alexis and to those who are working in the Committee on Human Rights is to carry on, because Scott really believed in it. And it's true what they said about Istanbul. I was so scared. He went twice or 3 times, and I was really scared because, you know, sometimes they don't look into the face of anybody and just put you in jail. But he went, he said, I have to go. I have to support colleagues. It is important, and it is important that people know about it. So, thank you again. It's been really very nice of Vincent and all the others to have this tribute to my husband, and I wish you a good conference, and thank you again.
Thank you, Laura. Thank you for your kind words, and we hope we shall be with Mind Scott in our head until the end. Okay? Thank you. I propose you to continue the conference. Laura, will you be with us? No? Okay. So you give me 1 minute. So that's the panel on EPPO at the starting point and the role, of course, of the defense in this new matter. We have distinguished speakers, of course, Andrea Venegoni della Cour de Cassation, della Corte di Cassazione, Lorenzo Salazar, Deputy Prosecutor General to the Court of Appeal of Naples, and of course our friend André Lasjak, who is the president of the Criminal Committee of the ECBA. And we also have the opportunity to have by video conference Mr. Fabio Giuffrida from the EU Commission. Fabio Giuffrida has worked a lot on the EPPO issue, and especially in terms of the implementation of the regulation in member states. I have asked him, I had a conversation with him, and because we are on the starting block regarding this EPPO, he will make the demonstration that this institution is on the way, and especially today and this week, because our representative in Luxembourg are dealing with the règlement intérieur, the internal rules to the practical rules of this institution, and Mr. Giuffrida will explain us where we are, and also the problem of the remedies, because as you know, on the work done by the EPPO as of course remedies, but normally on the national level, but for some issues we defense lawyer will be obliged to go before the Court of Justice of Luxembourg, and he will explain us this proceeding. I would like to give the floor to Mr. Giuffrida, if he is connected. Is he? Yes.
Yes.
Yes, thank you to be there.
Good morning.
Good morning. Yes. Thank you.
Can you see me and hear me?
Yes. Yes.
Okay. Perfect. I'll try to share my presentation. Okay, so good morning everybody. Buongiorno a tutti. I would like first of all to thank ECBA for the invitation to the European Commission, and of course for the organization of the event and the support also from the it is for me a pleasure and an honor to be here with you. Of course, I would have loved to be there, actually, in presence with you. So in my presentation, as David said, I would like to first of all discuss with you the legal remedies against the acts of the EPO. And then, if time allows, I will briefly tell you where we stand on the established European public prosecutor. And before we look into the legal remedies which are provided by the regulation, I would just briefly remind you of the structure of the which is of the essence to then better understand and discuss remedies. As you all know, the EPO is one of a kind body of the European Union because it will have a central office in Luxembourg, and in Luxembourg there will be the European Chief Prosecutor, who is Ms. Regin, and then Ms. Goveshi will be supported by 22 European prosecutors, so one European prosecutor per member. All the 22 European prosecutors form the College of Prosecutors, which will be the management body of the European Public Prosecutor's Office, but it will not have any operational power. So the College of Prosecutors will not steer, will not lead the investigation yet. Rather, this power will be bestowed upon the permanent chambers of the European Public Prosecutor's Office, which are a special body still at the central office in Luxembourg, and they are composed by the European Chief Prosecutor and 2 European prosecutors. The permanent chamber will take the most important operational decisions of the EPO, such as bringing a case to judgment, dismissing a case, or applying a simplified procedure, what is called in some member states a transaction between the public prosecutor and the defendant. Of course, the permanent chambers will not be in the position to lead the investigation in the member states, but looking in the EPO if they have not, so to say, foot on the ground. And this is the reason why the EPO has also a decentralized level, meaning that in each of the 22 member states, there will be at least 2 European delegated prosecutors, which will carry out the investigation on the ground. The European delegated prosecutors are national prosecutors who will work in the state under the instruction and direction of the permanent chamber. And this is the reason why sometimes the as double-hatted status, because they will be national prosecutor working under the instruction of a European body, or even better, in part of the European body, such as the EPO. The reason why I wanted to discuss briefly the structure with you is to show you that the EPO, although it is an European office, it is strictly embedded in national system because the investigation is carried out on the ground on a day-to-day basis by the European delegated prosecutors, and this has, of course, crucial consequences for the legal remedies against the act of the European public prosecutor. The key provision concerning the legal remedies against EPO is Article 42 of the regulation, which says that procedural acts of the EPO are intended to produce legal effects with third parties shall be subject to review by the competent national courts. This means that in your day-to-day activity, whenever your client will be subject to procedural acts, to investigative acts, such as search, seizure, order to produce documents, these acts of the EPO, these procedural acts of the EPO, shall be challenged before national court. So in this case, the avenues that defense lawyers will have to walk are the same as those provided for national investigation. And this is, let's say, the key rule in the regulation. So acts of the EPO, the procedural acts of the EPO, shall be challenged before national. Of course, as you can imagine, this was one of the most contested and debated issues concerning the EPO, because in principle, being the EPO a European Union body, it should be subject to jurisdiction of the Court of Justice. However, due to its peculiarity, due to the fact that the EPO activities will mostly be carried out by European delegated prosecutors in accordance with regulation and national law, the principle is that the acts of the EPO will be challenged before national court. However, there is one exception to this principle, which is laid down in Article 42, Paragraph 3 of the regulation, which says that by derogation from Paragraph 1, so by derogation from the principle for national courts to review the act of the EPO, there is one case in which the Court of Justice is competent to review, and therefore, should this decision be invalid, annul the decision of the EPO. And this is the case of the decision to dismiss a case, to drop a case. In this case, the provision to bear in mind is an act of the regulation, which says that when prosecution has become impossible, the permanent chamber, in this case the decision is taken by the central office, the permanent chamber shall decide to dismiss the case against the person on account of the grounds listed in the regulation and which you see in the slide right now. So death, amnesty, immunity, nebis in idem, and so on. So in these cases, so when the permanent chamber takes the case, then this decision should be challenged before the Court of Justice. So, for example, I assume that one of these cases would be when you will be assisting victims of the crime on which the EPO is investigating, though the opponent may be limited exactly. But in this case, if you want to challenge the decision of the permanent chamber to dismiss the case, then you should go to the Court of Justice and complain about the decision. For example, you might argue that the permanent chamber decision was not correct in the interpretation of nebis in idem as interpreted by the Court of Justice. Another case in which the national court will be competent is a case, apologies. Before moving on to that, I just wanted to add one thing. Of course, the Court of Justice, in addition to the cases in which it will be competent to directly review and annul the decision of the EPO, can and times should be involved in the proceedings of the EPO by the way of preliminary rulings. And the rules for that are laid down in Article 42, Paragraph 2 of the regulation, which says that it shall have jurisdiction to give preliminary rulings concerning validity of procedural acts of the EPO, concerning the interpretation or validity provisions of union law, and concerning the interpretation of Article 22 and 25 of the Regulation in relation to conflict of competence between EPO and national authority. So this means that when the validity of the act of the challenge before national court, of course, defense lawyers will have the opportunity to ask national courts to send a request for preliminary ruling to the Court of Justice in Luxembourg to ask for the support of the Court of Justice in interpreting EU law. For example, if you believe that the EPO has not correctly interpreted some provisions of the regulation, then you should ask the national court to refer the case to the Court of Justice for a preliminary ruling. And I would like to recall that according to recital 88 of the EPO regulation, and of course in line with the jurisprudence of the Court of Justice, national courts should always refer preliminary questions to the Court of Justice when they have doubt about the validity of acts of the EPO vis-à-vis union law. And then, so to give you another example of how this principle concerning the legal remedies against the act of EPO will play out in practice, I'd like to mention the example of the choice of forum. So the main principle in that case are laid down in Article 26, paragraph 4, and are recalled by Article 36, paragraph 3. And in essence, the principle is that the investigation of the EPO is then the production of the EPO. So the trial after the investigations should take place in the member state where the focus of the criminal activities, so basically in accordance with the principle of territoriality, or when there are more connected offences within the mandate of the EPO, the bulk of the offences in the community. However, it is possible for the EPO to deviate from this principle, but only in a duly justified case. It will not be a full arbitrary power. This power should be exercised only when there are justified grounds and only taking into account the criteria which are listed in order of priority in the regulation. And so they are habitual residence of the suspect, the nationality of the suspect, and the place, the main financial damage. So in practice, that could be the case, for example, of an investigation which started in Germany, because the focus of the criminal activity is in Germany, but the EPO believes that there are justified grounds to move the case to Italy, for example, because the place of suspect, the suspect habitual residence is in Italy. So in this case, the question is how to challenge the EPO's decision on the choice of forum. Again, the main rule as expressed in recital 87 of the EPO regulation is that the procedural act concerning the choice of the member states for prosecution shall be started are to be, so decisions concerning the choice of member states are to be challenged before national court. So in this case, it will be before Italian courts, and ask Italian courts, first of all, to assess whether the EPO has correctly applied the criteria which are mentioned in the regulation. And second, of course, there will be always the opportunity to mention to the Court of Justice if there are doubts about the interpretation of the criteria, so mention to the court, national court's opportunity to refer the case to the Court of Luxembourg for a preliminary ruling. So this would be the main rules concerning the legal remedies of the EPO. I do not know whether I have a bit more time to discuss what's left in terms of the state of play, or whether maybe we can discuss it later. This is a question to the panel. Should I continue just with one more slide about the state of play on the EPO? I think it's a yes.
Do you hear me? Hello?
Yes.
Yes.
Hello? Yeah. Okay, so thank you. So just one more minute to discuss the state of play. And in particular, what I wanted to mention is that, as you know, the 22 European prosecutors have been appointed at the end of July 2020.
Thank you.
The 22 European prosecutors, as I mentioned at the beginning of my presentation, form the college of the EPO. So, as you know, the wish of the Commission is ideally to make sure that the EPO will be operational by the end of November 2020. But of course, in order for the EPO to be able to start its activities, there are a number of crucial decisions, administrative decisions, shall be taken by the college. So we truly hope that the college can take this decision as soon as possible. And just to mention some of these decisions, the college should now, first of all, proceed with the appointment of the European delegated prosecutors, which are nominated by the member states. Likewise important are the internal rules of procedure, which should take a number of key decisions concerning the relation between the central office and the centralized level, so between the college, permanent chamber, and the European delegated prosecutors, and decide, for instance, on the number of the chambers. The college should also adopt the rules on the conditions of employment of the European delegated prosecutor. And finally, the college should also take a number of decisions which, so to say, concern the execution policy of the EPO, starting general guidelines allowing the European delegated prosecutors not to evoke the case and the damage of the crime is less than 100,000 euros, or guidelines on the application of the grounds for the allocation of jurisdiction. So this is definitely the first, these are definitely the decisions that the college should take as soon as it is formally constituted, which should be anytime soon. And from the rest, all the other administrative tasks connected with the establishment of the EPO are ongoing, from the work on the premises of the EPO to the case management system to the adoption of I would stop here, but I would be, of course, happy to further discuss this with you if you wish. And I would also like to thank once more for the invitation, and thank you all for your presence.
Thank you so much. André?
Grazie mille. So good morning, dear colleagues. Allow me to say some words on the procedural rights or defense in the European Public Prosecutors proceedings. I'm talking on behalf of the criminal committee of the CCB, and of course as an advisory board member of the ECBA. I'm very honored that I can be here in these times. I'm really happy that we organized the conference, so this is kind of double pleasure that I can see all of you here. So in medias res, just for a little introduction, I would like to focus your attention that attention of the existence of Article 41 in the EPPO regulation that regulates the scope of the rights of the suspects and accused persons in the EPPO proceedings. Just briefly, we have to understand that this article is mostly general and is not going into the real details. What is clearly said that there is granted a minimum procedural rights provided in the union law, including directives concerning the rights of suspects and accused persons in criminal proceedings as implemented by the national law, and there is a list of the directives, the directive on right to interpretation and translation, the right to information, access to the case materials, the right of access to a lawyer, and the right to communicate with the third persons, and the right to remain silent, and the right to be presumed innocent as provided in the directive from 2016, and the right to legal aid as provided in the directive also from 2016. Article 41, paragraph 3 is also very important to understand because it's also regulated that suspects and accused persons as well as other persons involved in the proceedings of the EPPO shall have all the procedural rights available to them under the applicable national law in a particular member state, including the possibility to present evidence, to request the appointment of experts or expert examination and hearing of witnesses, and to request the EPPO to obtain such measures on behalf of the defense. This is just only particular rights that are listed or formulated in this article, and we have to understand these kind of challenges that could come because as you know, the implementation of the directives had been conducted in a member state differently. There was actually kind of evaluation report made by the European Commission by some directives. For example, the directive on interpretation and translation. There were some results of this evaluation. Of course, there were findings that were not very nice to read. On the other hand, the conclusion was that the implementation was more than less successful. We in the Criminal Law Committee have a little bit different, as well as the ECBA, is a different position, and we think it's necessary to either adopt further regulation or further legislation in this matter, or to make the implementation better. The problem is that the national law or national laws in the particular member states could be different. From this point of view, it's not sure if the scope of the rights will be the same in different member states. What was actually said to my another panelist, Fabio Giuffrida from European Commission, DG Justice. He was talking about Article 42. It's the judicial review or and the problem is that this kind of judicial review will be made by the national court. It means by the national judge. In my experience, I'm sure this is the same on your side, that my experience that the national judges are not very aware about existence of the European Union law into the detail. Sometimes happened that I was talking about the directives, and the judges or the judge was looking at me, and he doesn't have or didn't have any clue about existence of such a directive. So this is, in my opinion, risk or threat that could occur. So from this point of view, we have to be really aware that the way how we are going to defense should be really accenting the existence of the European Union law and the not full implementation of the directives. Then some of the directives, some of the articles have a direct impact, what is also something that the judges, the prosecutors, and the police officers don't understand and don't know. So this is something that actually I use very often, and I argue with the directives and the direct impact, direct effectiveness of the directive. And then sometimes happen that really they don't know how to react, how to argue, and at the end sometimes I'm also successful just because of this argument. Going into the practical issues, regards the interpretation and translation, there is really, let's say, big variability among the member states how it works in the practice. You know, there is a right to have translated the essential documents. In some member states, there is no clear list of the essential documents in the criminal file. Of course, in the directive, it is described what is that, but in some member states happens that is just translated orally. And the defendant, okay, if he has a good memory, he can remember, but if not, this is not the proper translation. Also, very often happens that there's the same interpreter that is hired by police and that is used for consultation between the lawyer and the accused person or the suspect person. This is also something that could be challenged because, of course, the confidentiality is questionable. The other thing is access to the case file. Access to the case file, of course, should be under the condition or rules of the national law. There is such a big variability of among the member states and the national law when the access to the case file could be for some time limited because of the interference to the investigation. In another member state, it's a risk of violation of the rights of victim, for example. In some member states, there is a restriction when there is aspect of the national security. So this is something that should be definitely somehow harmonized, because otherwise we have to understand that in the EPPO proceedings there will be always or the most of the cases involve a few member states. So there will be disproportionality between the rights in one member state and the other member state. So this is something that, of course, it's a matter of some time, but I think the first cases could be really big challenge for the defense rights, and I'm very curious how it will work. The other problem is the legal aid. There is also different legislation and evaluation where is the need to have a legal aid lawyer for particular cases. Okay, I will. So legal aid issues also another topic, and very important topic is the admissibility of evidence. I'm going to finish. I would like to pay attention to Article 37 of the regulation, and please also read Recital 80 from the regulation, because the evidence obtained in another member states under another national law could be used in another member states and should be assessed by the court according to other national law. In my opinion, this could also make some troubles. Thank you very much for the time.
Thank you so much for your presentation. As usual, it is always clear and you know by heart the text, and thank you so much. Now I would like to have the point of view of the judges, because it is important, and Italian judges on the situation. Mr. Salazar, you have the floor.
Thank you very much. Merci beaucoup. I believe to have been invited here not that much as Deputy Prosecutor General in Naples, but mostly because I was involved in the EPPO project first, in the EPPO negotiations later. I was the chair of the working group of the Council negotiating the EPPO regulation, draft regulation, during the Italian presidency in 2014. So just to introduce myself. And I have, first of all, to congratulate the organizers of this meeting. I don't know if it was made on purpose, but you are certainly aware that this Monday, this week, we have the first meeting of the European prosecutors in Luxembourg. On the 28th of this month, September, we will have the ceremony in the Court of Justice for swearing. So really, we are working on something which is very, very actual at present. And going back with the memory, I would like to say that it happened for the relationships among EPPO and the defense lawyer, exactly what has happened more in general among in the building up of the European space of freedom, justice and security, among the prosecution and the interest of the prosecution and the right of the defense. First came prosecution. The first tentative to have directives in the field of protection of the right of accused persons goes back to the 2003, I believe, the first project for a directive on this, and which was never accepted by the Council. The Council, the ministers of justice were only occupied with negotiating instruments for, among brackets, repression, or in any case, to increase the level of cooperation among judicial authorities, among police authorities, and to improve the level of approximation of criminal law. This was all along the period of the Amsterdam Treaty until the entry into force of the Lisbon Treaty. After the entry into force of the Lisbon Treaty, at long last, we had the first directives in the field of the right of the defense. So, first came prosecution, later the right of the defense. The same with EPPO. We care, while all along the negotiation we care very much about the efficiency of the new body. I confess not that much about the protection of the right of the defense. There are clear, understandable reasons for this. This is for the national authorities which, as we have seen, the authorities in charge of the remedies. So there were practical reasons for this. But at the same time, I know I will not be popular among you, but let me say that the lawyers and the defense lawyers never look at this initiative with a lot of sympathy, and this is understandable. Neither they try to be involved in this, and I must remember, sorry for saying this, that the Council of Bar and Law Societies of Europe, the ECBA, issued in February 2013, which was just a few months before the presentation by the Commission of the new regulation, doubts about the desirability and opportunity of having such a regulation presented, saying that Olaf was largely enough and we didn't need, the CCBA didn't feel the need for having a European prosecutor. So, this is to say that if there was not the involvement, and I accept this, which should have taken place of the representative of the defense lawyers along the negotiation. I remember in many, many occasions where I was invited to a conference, etc., that there was some reluctance to accept the very same idea of having an European prosecutor. So I was sure that my excellent friend Giuffrida and also from this side of the table, the main articles of the regulations which deals with the right of the defense would have been already presented. So I will not say again, I would not talk again the three levels of protection, the charter, the directives on procedural rights, and the protection national level, which are all the rules provided for by national law for the right of the defense. So this is the basic principle, and I will not insist on this. I will just try to focus on some challenges because time is running. You are probably aware, if you look at the regulation, that the model of the European Public Prosecutor Office has been built very much, I wouldn't say in line, but inspired by a model of prosecutor which is very much close to the Italian model. An independent prosecutor who looks for the evidence both against and in favor of the accused person. This is maybe not that much familiar to many. And with the possibility for the defense lawyers to go to him and ask him to provide, to look for evidence also in their favor. What is lacking for sure in the regulation is the possibility, which is a possibility which is not either allowed in many member states of the European Union, for having defensive investigations, what we call enquête défensive, and we have this in Italy. There were discussions for having something similar provided for, but this is for the time being left to national law. So the situation is already providing for a discrimination, if I may, among different countries of the European Union, because in Italy a defense lawyer would certainly have access to defense investigations, while they will not have access to this in another European country. I would like to take this opportunity to remember a friend of mine, a lawyer, defense lawyer, Giovanni Bana, who is now disappeared with COVID, unfortunately, this year. And he wrote an article for EUCRIM where he insisted for trying to provide a legal basis for an harmonization or at least an approximation of the legislation on defense investigation at the European level. And this could be an opportunity because we could imagine, as it was the case for other instruments, to introduce this at least for the investigations and prosecutions by the European Public Prosecutor Office. Just think about this. Can we start from this for trying to approximate national law, in European law also in this field? Then another challenge, European Court of Justice. We heard about it. The possibility for going to European Court of Justice is provided. This is not my, but certainly a merit of the Italian presidency to have very much insisted for having a role for the Court of Justice, because the original proposal of regulation by the European Commission did not provide any role for the European Court of Justice. Everything was with the national judicial authorities. We wanted this. We wanted the Court of Justice to be involved. We didn't manage to achieve a result which was correspondent to our ambitions, if I may. But we have a role for the Court of Justice. You can ask the competent authorities of member states, the national judicial authorities, to go to the Court of Justice for, with preliminary rulings. And this is again with your professional experience and your professionality to try to convince the judicial authority to go to the Court of Justice, because there is a problem. And be careful, because if it was already explained that you can certainly go to the Court of Justice directly at some crucial stage of the procedure, for instance, when there is the acquittals from the placement by the European Public Prosecutor. This is a case where you can immediately go to the Court of Justice. In other crucial points of the procedure, you don't have a direct way to the Court of Justice. So you have to convince the national authorities that there is a problem. For instance, and this is maybe the most important problem, the choice of the jurisdiction. The choice of the jurisdiction will be under Article 26.4, what is called allocation of competences within the EPO. This is the moment where the college, where the permanent chamber, where the central level in any case decide who will be the competent European delegated prosecutor to investigate a case. So, and this is not necessarily the one in the state where the case started. So your clients could be obliged to go in another state to defend themselves. And this will oblige you as defense lawyers to run around Europe to, let's say, to defend your client. Because it could be the case that a case is initiated in Italy, then the central level decide that the European delegated prosecutor in France is better placed for this because of the criteria. I will not go into this by the, announced in the regulation, and at the very end, it is possible, and it's provided for by the regulation, that Germany will be the state where the final decision will be taken by jurisdiction. So run after this. This is really a problem. So this is one crucial issue, I said, and also by the point of view of the Court of Justice, could be crucial to say, by way of preliminary rulings, that there was, let's say, before the court, a mistake into the interpretation of the regulation. I understand that, Fabio, it was not very clear from the sound, but Giuffrida already evoked the possibility that also in this case you can go to the Court of Justice by way of preliminary rulings, asking the Court of Justice if Article 26.4 must be interpreted in a way that the center of the investigation is not in Italy but in France, etc., etc. But this is again with you to be so clever and to be able to convince the national authorities to propose a preliminary ruling to the Court of Justice. So again, time is running again, 11 minutes, so I use my final points to touch upon other challenges. You evoked right to interpretation and translation. The quality of this is essential. You will be confronted, everybody will be, but defense lawyer more than others, will be confronted with huge problems of translation. I deal with international cooperation in Naples, and I know how bad it could be, the translation of European arrest warrant, for instance, and also, in many cases, the interpretation. There are initiatives at the European level, and I call your attention on this, at the level of the European Association of Interpreters and Translators, EULITA is the name. You're maybe already in contact with them, to provide a good, sufficient level of quality. And this is really a challenge also for the future. So another point which was put to my mind by also what always happens in Italy, use of the media. You know, you're more than aware that sometimes trial happens on the newspapers, in the media, before happening in the court. And think about a possible press conference. I hope this will not be the case, but we always have press conference in Eurojust, Europol, etc. Think about a press conference by Madame Covesi saying that a big case has been opened with so and so. This could also be something influencing. On the one hand, I'm not convinced that the case falling under the competence of the EPPO are very mediatic. They are complicated case, financial case, frauds, etc. At the same time, an European press conference certainly has even more impact than a national press conference. So you must be prepared to also to this kind of issues. If there is a press conference by Madame Covesi, which impact will this produce on the investigations? So I will conclude saying that it's fundamental to have, let's say, a new category of criminal lawyers prepared to protect the right of the defense before the EPPO. The creation is also it's not only a problem, it's an opportunity for you. I think that unlike the cases of, for instance, of European arrest warrant, which usually are frequent for sure, but cannot provoke, let's say, a change in the organization of law firms at European level. I think that taking into account the importance of the cases and also the financial implications of these cases at European level, this could be an opportunity for justify an increased specialization of the law firms of European level, maybe having an expert on these matters who is able to follow a case around the different member states of the European Union, also inciting to have more contacts and among law firms in different member states, which can allow you to immediately react to a possible change of jurisdiction in different member states. And I conclude with the same wish which was expressed by Giovanni Bana in his article on this magazine, Eucrim, which deals with European criminal law. And you are aware that in 2009, a roadmap was adopted by ministers of justice on procedural rights. The result of this roadmap were the directives which were already presented. From already sometimes we are, and I include myself in those, among those who are asking for this, a new roadmap for procedural rights for the future with more, let's say, powerful instruments going beyond the fundamental rights already protected by the directives adopted. The investigative defense investigations, sorry, again, at European level could be one of this point, and certainly a new roadmap on procedural rights should take into account this new reality starting from November, December, January, but in any case, starting in a few months from now, which is the EPPO. Thank you very much.
Thank you so much. This was very clear. Thank you for your frankness, and thank you to have pointed out our role, which will be very often to convince our national jurisdiction to send the file for interpretation to the Court of Justice. Mr. Verigoni, thank you to be there, and now we would like to have the song of the Corte di Cassazione.
Well, thank you very much, first of all, for the invitation. But I have to say that the same thing as Lorenzo, that I imagine that I was invited in this conference not because of my current position in the Corte di Cassazione, although like all the judges, even the Corte di Cassazione will be involved somehow with the EPO proceedings. But probably I was invited because of my previous life. Before joining the Supreme Court, I was seconded for a number of years in the European Commission, and in particular in the European Anti-Fraud Office, OLAF. And just at the time of my secondment in OLAF, the proposal of the regulation on the PPO was at stake, so I had the opportunity to be involved. I contributed to the drafting of the proposal of the regulation, and I also started the beginning of the negotiations in the Council, obviously on behalf of the Commission, not on behalf of Italy like Lorenzo, but we met in these meetings in the Council, and that's the reason, I think, because I'm here. I think it's very important to discuss about the EPO with defense lawyers. I'm very happy to talk about EPO with you, because usually in our seminars and conferences, where we happen to go, very often with Lorenzo again, we meet judges and prosecutors, basically. It doesn't happen so often to discuss about EPO with defense lawyers. I don't know, even today, I don't know how many Italian, let's say, I speak for, I know better the Italian situation, but sometimes I wonder how many Italian criminal defense lawyers are really aware that in a few months they might be dealing with EPO proceedings. Because when I speak about the EPO with my friends or when I meet some defense lawyer, I see they are a bit disoriented. So it's essential to talk with the defense lawyers, also because the EPO regulation and probably the EPO proceedings will oblige the defense lawyer to face with a number of issues, a number of problems. The regulation is very broad, is very wide, it doesn't cover everything, there are a lot of gray areas. So I think it's very important for a defense lawyer to carry out its function properly, also to be aware of possible sensitive issues that are in the regulation. And just to be very concrete, very practical, I want to be very practical here today. We are not with academics. I don't want to make academics presentations. I have noted some possible issues that, in my view, are very important for a defense lawyer because they are key issues for the suspect. I mean, we have to obviously to remember that we are dealing about the suspects. The suspects are individuals that will be involved in the EPO procedures. So it's important for a defense lawyer to be able to move among the different provisions of the regulation. And it's not very easy. It's not very easy because the legal framework of the EPO procedure is not only made of the EPO regulation, but it's also made of the national law. And so there might be issues where you need to look to a different level of legislation, the European legislation, but also the national legislation. I just mentioned them very quickly, and then if you want, we can look more in depth on some of them. The first one is the basic issue of any criminal investigation, which is the definition of the criminal offenses. Which are the criminal offenses the EPO is competent with? Here we are already facing a first little problem because the EPO regulation does not contain any definition of the criminal offenses. But for the definition, it makes reference to another legal instrument, which is the so-called Peace Directive, a directive that was adopted more or less at the same time, 1 year before of the EPO regulation. The Peace Directive, as a directive, needs to be implemented in each member state. Italy implemented the Peace Directive last year. The problem is that, as it happens pretty often, the implementation is not the same, is not exactly the same in each member state. But the implementation sometimes is not also fully matching with the European instrument, with the directive in this case. So, for example, now we have, after the implementation of the Peace Directive in Italy, we might have some gray situations, because the definition of fraud, for example, which is in the directive, is not fully matching with the definition of fraud in our criminal code. Our definition is more general, but the definition is not exactly the same. The definition of corruption is not exactly the same. Regarding the VAT evasion, because the EPO will be dealing also with tax criminal offenses, the VAT evasion falls into the EPO competence only under certain conditions. So I imagine that there might be discussions. If a defense lawyer wants to carry out its function properly, he needs to be aware of that, because the case could be not an EPO case. It could fall into the national competence. This is the first issue. Another issue that, in my view, could raise some questions is the opening of the investigation of the EPO, because in the regulation, the opening of the investigation is a sort of double-stage procedure. First, when the EPO receives the information with the criminal allegations, it has to register the information and to verify if the information is grounded or not. Only when the EPO believes that the information is grounded, then it opens officially the investigation. This, let's say, double-stage system is more or less unknown to our criminal procedural code, because in our system, when the prosecutor receives the information, the registration is the opening of the investigation, let's say, unless some particular case, but I don't want to get into details now. In the EPO procedure, it will not be the same. This could raise some issues, because as we know from the opening of the investigation, under the Italian procedural code, which will be applicable to the EPO investigations, because the applicable law is the law of each member state, some terms start to run, for example, from the opening of the investigation. The question could be whether these terms start to run from the registration of the information. For example, if the information received by the EPO is already sufficiently clear about the existence of a criminal offense, or the terms start to run from the opening of the investigation. In Italy, this could be, for example, a problem. Another very important issue is the judicial review, but okay, we heard the presentation by Fabio Giuffrida. We have the problem of ne bis in idem, and I want to say something more in depth about that at a later stage now, but also in the meeting, in the working group today. We have the problem, the investigation, the relationship between the EPO and the EU states which are not EPO states and the third states, because after the establishment of the EPO in cross-border investigations, we'll have 3 categories of states. This is again something that a defense lawyer must know, because the legal framework changes depending on the situation. We have the EPO states, so the EPO area, which under the regulation is a single office, the EPO area. We have the EU member states that are not participating into the EPO, and for the investigation with respect to these states, the European Union legal framework applies, but not fully the EPO regulation. And then we have the relationship with the third states, where the EPO will have to use the traditional cooperation instruments. But first, the EPO will have probably to enter into some agreements with these third states, because if there is no extradition agreement with the third state, there might be a problem about extradition or about legal cooperation. Another issue which is partially linked to this problem is the issue of the cross-border investigations. even inside the EPO area, because despite the fact that the EPO is a single office, the legislation, the applicable legislation, is not the same in all the EPO area, because the regulation didn't provide with a sort of a common criminal procedural code. So in cross-border cases, each state applies its own legislation. That means that when, even inside the EPO area, when a European delegated prosecutor needs to undertake an action, an investigative action in the territory, let's say, of another EPO state, he has to use the legislation of this other EPO state. But then, obviously, the evidence will be used in the state of the prosecutor conducting the investigation. But the issue is that probably the procedural rules of the state where the evidence is collected are not the same rules of the state where the trial will take place. So this could create certainly some problems. There is a specific provision in the EPO regulation to solve, well, not to solve, but to govern this problem. But I imagine that for a defense lawyer, this is a big issue. You may say, but okay, this is the same problem that we have already today in the traditional mutual legal assistance instruments, for example, when in the European investigation order procedures. It is true, the problem is similar, but the difference between the EPO and the European investigation order is that the EPO, as we said, is a sort of single office, a single area, so the EPO will not use the European investigation order. The transfer of evidence inside the EPO area will be much faster and also, we can say, more informal than when using the European investigation order. This is very good for the prosecutor, but this could be a problem for the suspect, for the defense lawyer, because I imagine that, we can say, the control on the communication between the European delegated prosecutor placed in one state and the European delegated prosecutor placed in another state could be more complicated for the defense lawyer, because there will be no formal instrument. There will be some official steps, obviously, that must be taken, but for the defense lawyer is basically out of these official steps. So we'll see in practice what will happen. Another critical issue is the dismissal of the case, because, as we heard, the dismissal is decided by the EPO, so by the prosecutor. This is not in line with the tradition of certain countries. For example, in Italy, the dismissal of the case is decided by the judge. It's requested by the prosecutor, but it's decided by the judge. It's also a matter of guarantee, also of the victim. You can imagine, because even in the EPO criminal offences, there are victims. Not only the European Commission is a victim, but also an individual could be a victim. For example, a competitor in a tender procedure where there was an allegation of corruption, so he lost the tender because of allegation of corruption. If the case is dismissed, the competitor could have the interest to challenge the dismissal of the case. But he has no possibility to involve the judge, as it happens in some countries like in Italy, because the dismissal is done by the EPO directly. If he wants to challenge the dismissal, as we heard in the slides, he has to appeal to the Court of Justice. This is good in principle. In practical terms, could be a bit complicated, because the EPO investigation, after all, is an investigation at local level. So I will imagine an investigation in Reggio Calabria, in southern Italy, and the victim, if the victim wants to challenge the dismissal, he has to go 10,000 kilometers north to Luxembourg. In principle, there is nothing to say, but we know that there are also some practicalities in the preparation of an appeal, in the translation of the documents, and also sending the documents. In principle, in the EPO, everything should be based on the electronic files, but again, not every defense lawyer is so familiar with the electronic instruments. So I think it's good that you start to be aware of these problems, because in a few months you might be dealing with them. The nebis in idem, I wanted to tell you just something right now, but then I think we have a specific working group on it today in the afternoon, so today I can be more precise. But we know that today there are, we can say, two kinds of nebis in idem. The international nebis in idem with respect to proceedings that take place in another state, but today, thanks to the work of the case law of the European courts on human rights and the Court of Justice, there is also a very important issue on the internal nebis in idem compared to administrative proceedings which are criminal in essence, now the so-called matière pénale, called it by the Court of Human Rights. In principle, regarding the international nebis in idem, the establishment of the EPO should solve the problem with respect to the EPO area. I mean, the EPO regulation provides a system for avoiding double proceedings inside the EPO area. But the problem is not solved with respect to the other European, to the other states of the European Union which are not participating to the EPO. Again, that's why it's important to be aware of these categories of states. Then there are problems in the judicial cooperation that might be reason in a procedure. For example, when can we? There is a provision in the EPO regulation mentioning nebis in idem regarding the dismissal. The provision says that the EPO has to dismiss the case when the person has been already finally judged, we can say. What does it mean, finally judged? And here again, we have to recall all the case law regarding the meaning of final decision, when the case is dismissed by the prosecutor, or when the case has been closed on a basis of a decision that is not formally, let's say, an acquittal. But then we also have a huge problem. There might be a huge problem with regard to the internal nebis in idem. All the comments and the remarks that are currently ongoing in the debate in the legal world regarding the relationship between the criminal proceedings and the administrative proceedings will be probably applicable also to the EPO proceedings. If you consider a VAT case, for example, where it's very likely that the person will be subject to two proceedings, a financial proceedings and a criminal proceedings, if the punishment, the sanction on the administrative level in the financial proceedings is very important, is significant, this might have an impact also on the EPO investigation, because the EPO investigation is subject to the ordinary rules of the member states under this point of view. So in Italy, there might, but not only in Italy, but there might be problem with respect to this situation. And now, as you know, in the internal nebis in idem, we have reached a very interesting level regarding some decisions, even by the Supreme Court. Here now I can speak as a magistrate of the Supreme Court, because there is a sort of revolution, we can say, in the sanctionary power in the nebis in idem area, because the Supreme Court sometimes has said that when the first sanction, the administrative sanction, is so severe that somehow involves already all the sanctionary power of the state, the judge could also, in the extreme case, could could also not apply the criminal sanction, or could apply a criminal sanction which is significantly reduced compared to the statute of the Criminal Procedural Code. This is something that was, we can say, unthinkable until 5-6 years ago. This is how the evolution on the bis in idem is going, and all these problems certainly will also problems in the EPO investigations. That's why, again, I finish by where I started. I think it's very important for a defense lawyer to be aware of all these issues, because knowing or not knowing these issues can make the difference in the execution of your mandate to assist the suspect. Thank you.
Mr. Venegoni, thank you very much for your practical consideration. You have given to us the vademecum of the difficulties we have to solve in the future. So do not hesitate to join our office after your job at the Cour de Cassation. Thank you so much. So we are on time. It's now we have some minutes before the coffee break to ask questions to our friends and our guests. So do you have questions? Who wants? Yeah, André has already one question.
Merci beaucoup. I would like to ask you, our honorable guests, on the question of a double representation, or that the defendant would have two defense counsel, maybe in a legal aid, in two member states when there will be cross-border investigation, because this is questionable. Because there is a different legislation in some member states on legal aid. So this is the question, if you think there will be sufficient defense if in one member state the suspect, defendant will have the legal aid lawyer, and in the other member states wouldn't have a right for that, because the legislation is not so generous for the suspects.
I don't know, I would just, an immediate reaction. We know that the level of protection of the directive on legal aid is not yet satisfactory, because it only provides a basis, but it does not provide for, let's say, a real approximation of the legislation among member states. So it's true that we could have, let's say, discrepancies, and there is, I believe, and I hope not to say anything completely wrong. I am among professionals, so you know the matter better than me. The directives on the right of establishment and libre prestation de service and free, how do you say in English, service. No, la libre prestation de service. For the lawyers, you have the directives, which also should be considered when we think about the possibility for a lawyer not to establish, but to go to perform its activity in another member states. At present, I believe that we still have problems, concrete terms, because all the bars association have provided for some cautious measures, etc. But the new need of the EPO investigations provoke for the possibility to be immediately there to perform your services abroad in real time, if I may. And this is something which crosses the problem of legal aid, in my view. So if you are admitted as with legal aid in one state, I don't know how often it will be the case with this kind of investigation, because Possibly there will be wealthy people involved, but imagine that you are admitted to legal aid in Italy, then the case goes to France. Are you able tomorrow to be there to protect your client under the Libre Prestation de Service Directive, etc.? This is a question, but maybe Andrea has something else to say.
Well, I don't have a clear answer because this is one of those situations that are governed on paper, but we don't know how they will be implemented in practice. But I would tend to say, as the EPO is more or less a single area, or in any case, all the EPO states are also Schengen states, so there is a free movement also of the defense lawyers, because you are European citizens like everybody. Considering just a sort of informality, we can say, of the transfer of information and evidence between the prosecutors, I would say, just to be very practical, if your client, a suspect in Italy, understands that he must be questioned, for example, in France, because he is temporarily in France. I mean, if you are in a position to join him the day after for the interview, I think you can do it. I mean, I don't think you need to appoint a specific defense lawyer for this interview in France. If he's going to be subject to a search, for example, in France, that could be something a bit more complicated. He becomes aware suddenly that a search is going on. Even in that case, I mean, if you are in a position to be there in a short time, I think, I speculate obviously because we have no certainty about that, but I would say that you can join him for the search, or you can somehow appoint a colleague who is based in France. Then obviously, if you can have the legal aid in France or not, we should look into the French rules, because even for, I mean, the principle is that in the cross-border investigations, the national legislation of the state where the evidence is taken applies. So if the evidence is taken in France, even though the investigation is conducted in Italy, you should look into you should also look into the French legislation about that. But these are those situations that, in my view, has to be seen in practice, because it's
if I may, this is again for the wish list for the new roadmap on procedural rights. I mean, this is one of the issues which could be added to the wish list.
Yeah, and you know, because the biggest problem is that there is a European-funded prosecution, but national-funded legal aid, and this is the disproportionality, in my opinion. And the other thing is that usually the legal aid lawyers are not so skilled in foreign languages, and this is another issue that in cross-border investigation you have to, you know. Thank you very much. Thank you.
For languages, it's a matter of training of the defense lawyers. We also invited the defense lawyer to study foreign languages. But even judges, I mean, not all judges speak English or French. So
Thank you so much. Heiko, you have a question? No, take the micro, Heiko, the micro. Just.
Sorry. My question is, as a defense lawyer, how do I get access to the case management file? And why is there nothing, or I'm not clever enough to see it or to read it within the regulation? As an equality of arms, it is necessary to get access to the file. Thank you.
Yeah, with agreement of Andrea. You are referring to the case management system, which is the database where the files will go. The access to this is regulated, it's quite complicated to present, I will not enter into it. Even for the European prosecutors, they will not have access to it completely, I mean, to the whole of the file. They can have access to it an access limited to the data necessary to understand if there are overlappings among investigations. But this having said, this will be with national law. This is my opinion. I believe it's shared by Andrea. You will have, with the European delegated prosecutor, the same right of access that you have under the national law in national proceedings. So you don't have to go to Luxembourg. This is for the central level. May I say it's internal cuisine of the EPPO, but the central level will not have available more information that the European delegated prosecutor, who is the one who is really conducting the investigation, will have. So as far as you are allowed and entitled to go to the European, to the national prosecutors to have access to the file, you should in principle have the same right of access to the file which is in the hands of the European delegated prosecutors. For the central level, but we could continue discussing about this. I don't see a real issue because they will not have more information than European delegated prosecutors, and at the same time, even for the other European prosecutors not in the chamber, they will have limited access to the CMS. But this is a provisional answer, if I may.
Thank you. Thank you so much. Vanya?
Thank you. Thank you. Good afternoon. Thank you for your speeches and contributions. I would just like to recall that the defense lawyers, well, we were quite skeptical in the beginning, but in 2013 we wrote a paper, the ECBA, to propose some constructive principles for the EPPO, like accepting that it would become a reality. And during the negotiations, we also fought, and at a certain point, there was an article that actually had concrete procedural rights, rather than just referring to the directives. So we were quite disappointed that the Council did not like that, that article in that drafting. And I think it's going to be quite obvious when this EPPO starts working that there are a lot of shortcomings. I would like to raise an issue that we have discussed at the ERA conference about legal aid, because legal aid, people tend to think, wow, we heard this from the Commissioner when we were discussing the topic before the regulation was approved. Well, legal aid, why? But in these cases, people always have money, you know, there won't be any need for legal aid, they can pay for their own lawyers. I think that this is not true, because in these type of cases, there will be freezing of assets. I mean, as a citizen, I think it would be strange that, you know, if we're talking about very high value frauds and other types of offenses, at least where I come from, well, that involves freezing of assets. This means that even quite wealthy people might not be in the position of actually funding their defense. And one thing that is also missing is, how does this work? I mean, each member state has different rulings. In Portugal, there are no rules, so the judge might authorize or not to withdraw money to pay the defense lawyers, and that is quite a difficult situation, because the defense lawyer cannot, you know, like just invoice the judge for its work. So I think that, and thank you for the suggestion, this is an important feature that has to be discussed and has to have some harmonized approach, because in many countries, if you take on legal aid, you are not even free to choose your own lawyer. So how can you just have some random lawyer that does not even know that the regulation exists to defend you in these cases? So I think this is one of the most important topics, but the ECBA is working on thinking about this, and we would be very happy, of course, to exchange views and to contribute to, in a constructive manner, for the EPPO to deal with these practical issues. So to think of ideas, how to work out access to the case files in practice, how to make it work, or how to deal with these type of practical issues. Maybe there is room to do it in the internal guidelines or the regulation, and I think we are quite available to give some good ideas.
I cannot but agree to this. It was not a real question, but again, I want to insist on the fact that the Legal Aid Directive 2016-1919 is not satisfactory. The level of approximation is very low. There is already a distinction among legal aid in general and legal aid for the European arrest warrants in the directive. So there is, let's say, a form of suggestion, meaning that for the EPO proceedings, you could imagine to have, let's say, an addendum to this directive dealing with this case, because I would not be surprised if we could imagine to have, let's say, an European fund to finance legal aid only limited to the European Public Prosecutor Office proceedings. Why not? So again, this is for the wish list for the new roadmap, but you already have, let's say, an input by the distinctions already existing in the directive among the European arrest warrant procedures and the other criminal proceedings.
Thank you so much. Amedeo, you have a question? Amedeo, use the microphone, please. No.
Problems also between lawyers in knowing which is the EPO system, how it will work, but I have some fears also about the training of judges, because we already all know, and every day we experience in court that the knowledge of European law by judges is not so high. It's not so. We have problems in proposing preliminary references in daily life in court. So, I think. Do you think that the judges at national European level are doing enough training to be ready for the EPO system? But I think it's a big challenge also for judges. More than for prosecutors, there will be selected prosecutors with high specialization, high skills, because they will be selected, but not because we have a natural judge, for example, into the principle of natural judge. So maybe an EPO case will be handled by normal judges that every day just deal with the national cases. And I think this is can be a problem, because I know that generally speaking, I know that there are exceptions, but generally speaking, the awareness of national judges, for example, they are not really used to work with the preliminary.
Well, if I may, I also wanted to say something regarding the previous question on the level of harmonization. Let's say, just to be clear, in the negotiations, the Council had to make a choice whether setting up a detailed set of rules, procedural rules, at least for the EPO criminal investigation. I don't want to say a European criminal procedural code, because maybe it's too early for that, but at least detailed procedural rules, including the defensive rights, or to let the governing of the investigation to the member states. The choice was the latter one, the second one, because even the proposal that the Commission submitted in 2013 contained a higher level of harmonization than the final text. Maybe not on the legal aid, but on the investigative matters. That's a choice. I always said many times, and maybe I also wrote it somewhere, but almost in each conference where I had a chance to speak on the EPO, I always said that in my view, setting up a specific number of procedural rules, including the rules on defense, is much more protective for the suspect rather than leaving the situation in the hand of each member state, because the current situation is pretty complicated for the suspect, not only for the prosecutor. I always found very strange that those who invoke more protection for the suspect's right sometimes are not in favor of a detailed set of European procedural rules, because the best way in cross-border investigations to protect the suspect in a cross-border investigation is to set the same procedural rules in one state and in the other state. Everything would be more clear and easy, also for the defense lawyer, not only for the prosecutor. But okay, that's it. This is the situation. I mean, maybe in the future, never knows. Someone can think about amending the regulation in this direction. Who knows? Regarding the training, it's true. Even the judges and prosecutors need to be trained, because it may happen that in a short time a judge will be dealing with a request, for example, for detention or remand, or for the confiscation, the seizure, coming from the European delegated prosecutor. So at least the judge should be aware, first of all, of what a European delegated prosecutor is, but also of the kind of procedure for the execution, for the implementation of this measure. I can speak for the Italian judges, obviously. There are a lot, already a certain number of trainings for judges and prosecutors in Italy. The School of the Judiciary is organizing, I would say, almost every year, some courses on European criminal law, including the EPO. Regarding the preliminary referral to the Court of Justice, it's true, the judges should be also familiar with this kind of instrument, but if we look today at the, I don't have statistics in my hand, but I have the feeling that if we look at the how many preliminary referrals are done to the Court of Justice, I think that most of them, or many of them, come from Italian judges. I have in mind some of the most important cases of the Court of Justice in the recent times, like... Okay, no, I'm not saying that they are the best, but I think the Italians are pretty active in this. But not only, every judge should be aware of that, but if you ask me about the Italian judges, I would say they are more or less familiar with these tools. The situation can always be improved, obviously, but I'm not particularly concerned about that, because I know that there is a certain awareness, at least in the Italian judiciary. Obviously, not everywhere in the same way. There are also colleagues, when I mentioned the EPO, some colleagues don't know anything about the EPO, never heard about it, but there are also colleagues who are very well prepared.
Thank you so much. I propose to continue our discussion around a cup of coffee, and then we go back to this room at 12:10 or something like that to continue our conference. Regarding the formation, just an information, ERA, de Europäische Rechtsakademie, will organize with us, with ECBA, seminars on EPPO for criminal defense lawyer. We shall circulate the information, of course.
So, dear colleague, cari amici, we are going to start our, everybody's coming back, so I hope we can start in order to be on time because we have still some work to do today. Today we had a perfect demonstration of what does it mean to have a video link or a video participation. I think we couldn't have demonstrated in a better way as poor as is the participation through video. We experienced it this morning, the participation of the person from the Ministry of Justice or the colleague from the European Commission, and it's clear to everybody that video participation doesn't mean exactly to participate, to be present. It's completely different. Today is a pleasure that we have the opportunity to discuss with you all here in Rome the problem deriving from digitalization of justice and the use of video link in criminal trials. The pandemic crisis forced us to use more digital, to starting working with the platform like Zoom, Jitsi, Teams, maybe that we never heard about before the pandemic, but now we are all experts of this kind of platform. The pandemic crisis changed a lot of our habits, changed the way in which we interact with our colleagues, with our friends, with our clients, with judges or prosecutors. Everything is going to change, and it's also a great challenge for us, for criminal lawyers, to understand that if on one side it's impossible to stop digitalization, it's impossible to stop the evolution of technological means of participation, we have to be really aware of not losing with these new tools, with these new instruments, the balance we reach and that we call fair trial, that is made of the presence of the defendant into the courtroom, the possibility to sit aside the defense attorney, to be seen into the eyes by the judges or by the prosecutor, to question a witness in presence, looking into the eyes, looking at the movement of the mouth of the person that we are questioning in a courtroom. So during the pandemic, in a phone call with Vanya, it was maybe April, still in the middle of the pandemic, we had the idea to starting working on a possible statement, put together lawyers from many different jurisdictions, different experiences, to understand what is possible to do with the digital, with the video participation, with the video link, and what is not possible for us, for criminal lawyers, to do with video participation. And so we started a long discussion involving many colleagues, many friends, and we had some video meetings also through Teams and together just to discuss what was possible. And the result is that is an ongoing, is a work in progress. The result is this statement we are presenting today that is in your material. I think it's an interesting document because we try to face the problem without prejudice. Trying to understand if there is something positive into the video participation and what is impossible to accept for us, for criminal lawyers. So that is the document that we are going to present today, and I leave the floor to Vanya just to illustrate the structure of the document, the so-called table of contents of the documents, and also to explain also why we decided also to make a distinction between cross-border situations and just domestic situations. Because I think also this distinction is important and can have different consequences, and can also, the way we decide to accept maybe more digital, more video participation can differ also in a situation of a cross-border situation in just domestic situation. Please, Vanya, I leave you the word. Can you put the table of content? Okay, perfect.
Yeah. Good morning. Good morning, everyone. Thank you, Amadeo, for this introduction. I'll be as brief as possible, and I would just like to present you with the structure of our statement, It's on page 107 of your bundle. And I hope if you didn't have time to read it, maybe when you're flying back home, you can read it in the airplane. It's a nice reading. It's, we hope. So we divided, in our discussions, we decided to make two types of divisions between this topic of using video conferencing in criminal cases. And the first major split was cross-border and domestic. Why? Because we know in practice that the consequences for the right to be present and the right to be able to participate are quite different when you're in the domestic setting or in the cross-border setting. Because basically in the cross-border setting, I think that's our new participant. We have someone participating online, so so basically in the cross-border setting, sometimes the fact that you don't attend in person means, well, you can't participate at all. So either you have no chance to participate in your own case, or you'll be arrested and extradited, to use the English version, or surrendered to another EU state in a situation that normally would never happen in a domestic context. So average medium cases, low-level cases where people typically are not in detention might be transformed in EAW cases in the cross-border context. So we accepted that in general there might be more advantages for using video conferencing in the cross-border context when, like weighed upon with the disadvantages of this. So we made a division between the cross-border and the domestic cases. We are a bit more skeptical with the use of video conferencing in domestic cases than in cross-border cases. And we also divided in these two groups, pre-trial and trial. Pre-trial, this is an European white paper, so we could not detail all the different hearings, but pre-trial hearings could have different purposes. Of course, typically just to, investigate, to hear the suspect. Also to impose pre-trial detention, coercive measures or the coercive measures, and to confirm it or to review it. And in certain member states there is also a phase between the investigation and the trial where you can try to challenge the indictment, or if you're the victim, where you can try to bring an indictment. So we divided these stages also and the trial stage. What are our, we try to summarize the proposals for this and just to try to give you an outline of what was our conclusion. So generally speaking, for the cross-border context, we do accept the use of video conferencing, especially when the alternative is that the case will proceed without the person being able to participate at all, or if the person would have to be detained and brought physically to the state of the proceedings, just because he lives abroad, without any other justification. So in this, with this vision, we typically accept video conferencing, but we also recognize that, it's, as we saw this morning, you can't just accept it because it has to work. So the first principle is we accept it. But then we need two things, and that's why we divided in both settings what we called legal requisites or legal safeguards, so legal framework or legal principles that we think that need to be implemented when using remote technologies, especially for the trial, because it should, it should allow for the participation to be as much as similar as possible to the real life experience, even if it's never the same, but it should be possible. For example, the suspect, the defendant, should be able to see the courtroom, not only one person at the time. So you should have an infrastructure that allows for this. That's why we also have a chapter on technical. It's towards the end, so this part we put together. On the, it's so small that I can't read it myself. I have to. No, it's chapter D of our statement. So we have the technical safeguards. Of course, as you might imagine, we are not IT people, so we did not do a detailed guide of what are the technical safeguards. So we tried to also put some principles together of what should be the technical safeguards for these video links in order to improve it. And we recognize that the more it improves, so the more we develop a robust legal framework, and especially in EAW context, there is a lot of potential already in the existing legal framework that we point out in the text that you can read to do it. So the more we improve the legal framework, the practicalities of this, and the more we improve the technology, the more we can use it. So this is a challenge for a European legislator, which we recognize, because the first issue is that the systems are not compatible. This is something that has been already mentioned in many studies. We don't know either, but we will continue to work. Why are these means underused in such cases? Because in many cases they are not even used. And our experience, although we did not do a comprehensive empirical study to find out the reasons why they are not being used, but from our daily practice in courts around Europe, what we feel is that first, the parties, the judges, the lawyers, we don't trust it so much because of the quality. The quality is not good enough. And secondly, there are a lot of domestic legal frameworks that do not allow for the use of video conferencing for the suspects. So if you're the suspect in many countries, you need to be in the physical presence of the investigative judge or the prosecutor during the investigation. And we think this doesn't make sense. So this might require amending legislation. Either the states would do it on their own will to adapt to this new technological world, or it would have to be the Union or Council of Europe legislating. Because in most instances, you don't need the physical presence of the suspect. There might be some where you actually need the person to be there, but I would risk to say that in the overwhelming majority of the cases, this is not needed. Finally, just to finish, for the trial stage, there is a difference in, I think the sharpest difference in the paper between the domestic and, so it's, I think the pre-trial detention hearings and the trial hearings. Why? Because of course the trial is, you need a lot of infrastructure and a very different infrastructure to allow for a trial to take place in remotely. And you also need to define what is a remote trial, actually. We are pointing this out. But the fact is, and by no means we want to propose that states start to do trials in absentia. That is not the purpose of our paper. But in this day, today, many states are doing trials in absentia. And so we wonder sometimes, so the same states that are doing trials in absentia say that they don't allow for the suspect to participate remotely. And this doesn't make sense because the restriction of the right to be present and to participate is much higher when you are not even able to participate. So even if remotely, and of course we say there is a need to improve the technology available to this and the legal safeguards, it's still better to be able to attend remotely, especially in low-level and medium cases, than not being able to participate at all. So I think this was the ground idea of our paper. So.
Okay, thank you, Vanya. Thank you for your presentation, but also for being the real soul of this work we did because of the working group on video participation. And I think it's important because day by day we see, and maybe we don't know when this pandemic crisis will finish. We don't know if we came back and when we came back to the normality of the tribunal life, but we know that we cannot suspend rights in this time. We neither can suspend justice, but on the other side we cannot avoid to defendant to be part of his trial, her trial. So I think it's fundamental to have some point that are not negotiable for us, that are right, because we are dealing with rights. Dealing with the participation means to deal with fundamental rights. And so for us, as criminal lawyers, is so important. This argument is so important. Now I think we have Juan Palomino from Spain in a cross-border video participation. So Juan, hi. I welcome to Rome, to this Rome session of our conference. And I ask you are in the best possible position to explain how is participating in a cross-border video link And maybe you can also explain us which comments on our proposal and which are the questions in cross-border situation, and maybe also which are the technical safeguards we can put in action. Please, I leave the floor to you.
Thank you very much, Amedeo. Unfortunately, I'm not able to be there with you in Rome, so I'm missing this one. But we wanted to still do this through video conference, perhaps to show practical issues that we could face in cases in real time. So hopefully the quality won't be very poor, and I will be able to get my message through. I think I wanted to comment you especially on one of the statements that we included in the paper that we're presenting today, regarding the importance of defining perhaps what we understand by remote trial. I think that this is something very important, and I wanted to share with you how things, the Spanish experience and how things have been dealt with in Spain during the pandemic. And for this purpose, I wanted to share with you that there were some regulations that were passed whereby it was stated that courts had to preferably use remote means. And of course, it wasn't an obligation on courts, but only when they had sufficient electronic means, which, as you may imagine, most of the times it wasn't the case, right? So in practice, the way that this has been done, and I wanted to share with you on a specific case. I had a trial I had actually before summer from Madrid, and we had this trial, and we had this witness that was abroad, and of course the guy didn't want to travel to Madrid. There were some restrictions using this software. The Madrid courts have this license, and they have been using the Zoom application. So it wasn't like a super important case. The offenses were not very serious, but of course we were having this witness that was being deposed through this Zoom application from his mobile phone, and you know, this actually got me thinking about the practicalities and how this effectively can affect fundamental rights and due process, as went out in the paper. Probably not just because the technological matters, but also because of that the witness is not probably, in this particular case, he wasn't in a courtroom, wasn't being supervised by a public servant. And I think that this really could affect, especially cross-examination. And for us, defense lawyers, I think that cross-examination of witnesses is really important. In this particular case, we couldn't see if he was actually reading any papers, if somebody was actually in the room with that person, actually instructing the answers or giving some sort of way out to the questions that we were asking. So I think that in that sense, I understand that the situation is what it is. But I think that from that we had to deal with. I think that besides that, also for the judge to actually assess important things of that testimony of the and so on was also affected. And finally, I think that are we willing to rely on the connection of someone if that connection is working well or not? I think that, I don't know if you are hearing me correctly, but at least right now I'm a bit nervous that perhaps you're missing some of the things that I'm saying, you know? There we go. So it broke down. Finally it broke down, right? And I was going to say that as an alternative, as a technical alternative, I have seen, and probably some of the professors in the room have also seen it. Some universities are actually using softwares, very good softwares, whereby actually the software is done to supervise exams and to see facial movements and to see if someone is looking out of the screen and to capture sounds. So perhaps this could be an alternative for these kinds of situations. And I think, Amedeo, that was all I wanted to do, and on a timely manner. So I stuck to the 8 minutes.
While Constance is going there, one of the points that we recommend is exactly to have the person being heard remotely, not to be heard from home, but to be heard in a court or in a police station and in some official place where, you know, there is certain control of that the person is not being interfered with.
I think Juan gave us a very good example of what is video link and how it works. Now I leave the floor to Constance. Constance is from Paris. She'll talk us about video participation in domestic situation in pre-trial stage. I just want to remember that in France they had an important decision by the Constitutional Council, I think, during the pandemic, also on video participation, if I remember well. So maybe France is a good laboratory for these evolutions, and the debate is more advanced than maybe in other countries. Please, Constance.
Switch that on. Is that better? Thank you. So I'll try to give you the positive aspects of video link. Yes, there are some. But so thank you, Amedeo, for being so cunning. We should probably go into politics. So I think maybe one of the questions that we need to address when looking at video link is this tension of criminal justice being both a public service, and as such it needs to be cost efficient, to be, you know, reliable for taxpayers, so on and so forth. And on the other hand, it's also a kind of sacred ritual. And I don't think I need to linger much on that with you all practitioners, because you all know that criminal justice and the criminal trial in general is the moment when society restates, re-chooses the values it's protecting and promoting. So that's also why there's all this ceremony. I don't know how to go back to the, yeah. Nothing very sacred about that. And that's why, you know, there's this whole ceremony around trials. We go to grand places, we wear robes, we have special codes. So yes, there is something sacred about criminal justice. So on the one hand, video link can help the public service, and particularly during the pandemic in France, for instance, criminal justice virtually stopped, and it was a disaster. And for taxpayers, it's not acceptable, and for us, it's not acceptable. So yes, for the citizens, video link could be a good idea if you look at it from a public service perspective, but if you look at it from the sacred ritual perspective, it's just a cool technology, and there's nothing very sacred about it. So how do you reconcile these two visions so that criminal justice does not become mundane or trivial, but yet it remains efficient and functioning in case we have more pandemics and more problems? So I wanted to share with you this quote. It's actually from a French judge, Antoine Garapon, and he said, "Technology should not impoverish the human experience of justice." And I find it very good, and I would say, could we make technology enrich the human experience of justice? And how could we make technology become a good tool for our justice systems? So I've been asked to focus on pre-trial stage, and I'll address two issues. First, video link used for investigation purposes, and then video link in the context of pre-trial detention. technology again. So, video link for investigation purposes. Pros, of course, it's more cost efficient, it saves time, but also from a pure defense rights perspective, it could be that there's less undue pressure on suspects and accused because they're not being detained or even being interviewed within the police premises, for instance. So there's less coercion, less restraint, so it could be a good thing. And also, during pre-trial stage, it could help the police interview more experts, more witnesses, so it could actually serve defense rights. On the other hand, what are the risks? Of course, we all know them. It's less human, because human interactions are just not the same, be it remotely or in person, and we all experienced it, I think, during the pandemic. You probably had family reunion via video link. It's not the same. And I think police officers and investigation magistrates are probably going to oppose it just as much as us, because they would be prevented from seeing the body language. There would be no informal chatting before and after the interviews. So all this is definitely not trivial, not neutral. There's also a risk that the suspect might not be familiar with the technology, and so he might be further destabilized by it. And very interestingly, in France, we have a public authority monitoring all detention facilities, the Contrôleur Général des Lieux de Privation de Liberté, and he issued a public statement saying, we know that defendants in criminal proceedings very often already have issues with languages, with expressing themselves, and so video link might further impair their ability to express themselves, to communicate, and to speak up in court before a judge or before police officers. So in the ECBA statement, which only focuses, you'll see, on interviews of suspects and accused, we stated that it should only be dedicated to minor offenses at the pretrial stage, and that it should happen only with genuine consent being given by the suspect or accused, so probably with full information, maybe a kind of a lesser of rights like we have for police custody, and access to a lawyer before deciding. So that's for investigation purposes. And now, moving on to pretrial detention. So yes, we have this issue in France that in the context of pretrial detention, there are instances where the judge can just refuse that the client be brought before him. And so that's what I was saying when we had this discussion. In a way, video link could be better than nothing. But the problem with better than nothing ideas, it's little by little, it tends to become the rule. So we need to be very careful what we accept and what we tolerate. And I think we really have to draw clear lines. So once again, it's good. It saves money and time. In France, we had, in 2009, there were instructions given by the Ministry of Justice. So courts of appeal had to reduce the numbers of detainees they actually brought to court by 5%. And if they did not succeed in doing that, the ministry would cut the HR budget. So that's the kind of policy which is, in my opinion, very dangerous. Costs in criminal justice cannot, of course, be everything and cannot be the key criterion. Lots of issues here for pretrial detention, of course. Access to the judge. Is remote access as good as actual access to the judge? Active participation of the defendant to his or her trial, and I wanted to share with you these pictures. So bear with me, it's a bit technical. Here you can see, so it's the Court of Appeal of Rennes in Brittany in France, and here you can see the defendant on his own in prison. And here you can see the court. And if you can imagine, the screen is actually in a weird angle of the courtroom, because it's the same courtroom, but they just added a screen. And the screen is behind everyone, and so everyone has to turn to look at the defendant. And of course, after 3-4 minutes, no one turns. And so they're just looking at themselves, at the courtroom, and then defendant is just left out. And so there's this risk of the defendant. So the defendant used to be present with his lawyer, the public prosecutor, and the court. That's fine. And we move on to that. There's the court, the lawyer, public prosecutor, and the defendant, he's not there. He's not participating. What kind of an impact does it have for someone who's already being detained, who's already been marginalized? Because that's what detention is about, taking someone out of society. So what kind of symbolic aspect does it have? And there was one very interesting study saying, yes, it can maybe save costs not to bring detainees to court, but it might also lead them to file more and more requests just before they don't feel like they've been heard by the judge. So they would file more and more petitions. So in the end, it might actually not be that effective. And then what's the impact on impartiality and presumption of innocence? And I should state again that we're at pre-trial stage. So everyone here is presumed innocent. So what kind of impartiality do you have when you have one defendant who's not even in court? And what about equality of arms? The public prosecutor is seated just right next to the court. And here you can see the public prosecutor. The defendant is not here. So the public prosecutor will probably be in a position to have an informal chat with the president. There will be no technical issues. He will be able to deliver his speech normally, not the defendant. What about equality of arms in these cases? And last but not least, defense rights. So in that case, the lawyer chose to be in court in the case of these pictures. What about you all? Where do you choose to be? Do you go with your client so that he doesn't feel all alone? Or do you go to court because you know that's probably where you will make the more impact, where you can have an informal chat with the public prosecutor or the president afterwards? What do we do? How does this impact defense rights? How do you have an informal chat with your client when you're not even next to him? So, lots of questions, as you can see, and I just wanted to share with you a last quote. Or not. Yeah. So it's just a quote from a sociologist, and she's saying, from the day, so it's a French perspective, but I think it applies to each and every one of your countries. From the day the Criminal Proceedings Code enabled video link, everything has been done as if there were no difference between physical presence and remote presence, whereas the absence of physical presence associated to the use of that new technology is far from being neutral. And I think it's excellent because it's not saying it's good or it's bad, it's just saying it's not neutral. Let's stop saying it's a good enough substitute to presence. It's not the same. And I think it's very good that the ECBA took a stand just to say it's not the same. And in some cases, like international proceedings, it might be a good idea, but in some cases it might be a bad idea. And last thing that I wanted to share with you, to keep on being on a positive note for our chair, is just that video link could also be a good thing for us in the course of criminal proceedings. For instance, could we maybe liaise more often with our detained clients through video link? Could they maybe talk with their family when they are staying in other countries via video link? So lots of issues to be explored, and no, it's not neutral. Yes, it can be good.
Thank you, Constance. I really appreciate your presentation. I completely agree with your points, and as you know, for criminal lawyers, for criminal defense attorneys, it's impossible to be too much pro-video link. And as Constance perfectly said, technology is never neutral. Technology is never neutral, and it hardly can be in favor of the defendant. And the criminal trial has been built up to defend the defendant's rights. So maybe putting the defendant outside the courtroom means to put aside also the defendant. So what has to be the heart of the criminal trial. Thank you, Constance, and please, Nicola.
Dear friends, dear colleagues, just let me say a few words. First thing, I would like to take the chance to thank Vanya, because she was amazing in pushing the working group about the video statements. She took it with really a lot of effort, so thanks a lot, ECBA, for allowing us to make this important statement, because just to be clear, we defense lawyers are not against technology. We love technology if it's used to expand the effectiveness of the rights. We hate technology if it's used to limit the rights of the defendant. The ECBA statement has a lot of important issue and is dealing with a lot of problems. Today I would like to speak to you honestly and frankly about a very particular thing, the defense lawyer points of views. Should we allow use of video link in our trials? In the statements you will see words like consent, the personal free choice of the defendant. We speak about waiver. We would like to have effective information. And of course, the publicity of the trial. I'm not going to speak to you about that now. I would like to speak to you about the dark side of the trial by video link. Because for a criminal defense lawyer, it reduces the time. We don't have to travel. We can do it from home. We have no waiting time in court. We might think that trial by video link could be a good idea for our personal security in times of pandemic. We may avoid the human engagement with our client. Hundreds of questions, dozens of time, every time the same thing, and tears, and needs to hear that we are going to win and nothing is bad is going to happen. So less relationship with our clients is an issue as well. And for those of us who are not really willing to prepare the cases properly, we can avoid the questions from the client and to explain things that we might not be able to answer properly. So it's more difficult for the client to choose a lawyer who is really effective in the defense. Of course, there are a lot of other advantages for defense lawyers. Because we have then to think about the fact that there are a lot of disadvantages for the defense, which is, it has been already mentioned, the choice, where do we have to sit? Where is the defense lawyer place? Is it in court? Because it's useful and necessary to be in court, isn't it? Having some small talk with prosecutor, maybe trying to gain house arrests if, and it needs some informality here. Or is our place beside our client? This was never a question for us until the pandemic. Do we have to stay with the client in the prison? Or do we have to move and go to court to talk prosecutor and judge? Where is our presence required more? The relationship is affected. And if a relationship is affected, it goes about how much information do we lose by just talking to our client in video link. Because everybody has defendant, one single client and only one client in his life, knows that when we come up with questions, the defendant will talk about completely unnecessary things in the first 5 minutes. What if we have a 10 minutes slot to speak with him before the trial starts or the hearing starts? How much information are we going to miss? We have so many things to discuss, not only about the case, not only about the information to give him, but do you have a job? Who has your document information, the evidence of the fact that you have a house to be put in house arrest, and so on. We need to exchange documents. If something is presented at the hearing, we need to have our client immediately available. Of course, we could ask, Your Honor, we need 5 minutes to discuss that with my client. And we could send him an email saying, what do you think about that? But how many times are we going to do that in the same hearing? Compared with the fact that your client is sitting next to you and you can just show him. And in cross-examination, how important is it to have your client confronted with the new information and with the new witness statements? Is it true or is it not true? Did you wear a red tie or didn't you wear a red tie at that moment? Things impossible to prepare in advance. The confidentiality is an issue, isn't it? Italy, I think European Court of Human Rights in Strasbourg loves Italy because they use us to make perfect statements. Italy has been convicted by European Court of Strasbourg because we had a lack of confidentiality, because the trial on VideoLink, it was 2005, 2006, I think, there was a police officer listening to client and lawyer. Who grants, which is the technology is used, who owns the technology, who owns the data, how can we avoid to be intercepted, or let's say it in another way, maybe more gentle, how can we assure confidentiality pre, during and post-trial? And of course the technical problems that we may have had a perfect example today during our conference. So there is another disadvantage for the defense, which is what are the psychological effects on decision for the judges to decide about somebody's, I would emphasize if I said life, but how many years do you get? I'll show you a short video. It may contain some very cruel images, so please be advised.
Holy shit! Citizens report.
I told you over there. It is not, criminal lawyer is not about being gentle. Whoever played Grand Theft Auto or some shooting game knows how it is for everybody to kill people, to have very strong behavior, not to be affected by blood coming out, floating over the screen, and hearing these screams. And what does it mean for a prosecutor to ask for 10 years of conviction without the defendant being physically present, without having the defendant in front of him, looking him in his eyes? And how could it be for a judge to sentence somebody when she or he knows the defendant only by video, and knowing that in a second after the decision, the connection will be interrupted? There are advantages of video conferencing. The testimony of the witness is mediated by video screen. Studies have suggested that television and video screens necessarily present antiseptic, watered down versions of reality, as we have just seen. Much of the interaction of the courtroom is missed, or as the US jurisprudence pointed it out in 1993, videotape is still a picture, it's not life. Thank you for listening.
Thank you, Nicola. we try to be on time, and I see we succeed in this. Okay. Okay. Before leaving the floor to the next people speaking, I want to ask you if you want to join our working group on the video participation. You are free to contact Vanya, me, and join our working group. Thank you. Enough time for the discussion, but if somebody wants to make a short intervention or a short questions, we have few seconds still to use. Otherwise, we go through. Okay? No point. Yeah. Okay, please.
Hello. I created an association in France, in the Paris bar, called Cerveau Droit, which is specialized on links between law and neuroscience. And also for the Paris Bar Council, had to deal with the experimentations of the video conference in Paris, because the French ministry is testing something concerning the video conference. And I'm really afraid by the fact that the judges are not really fully aware of the fact that their decisions comes from the brain, and then they are really, as all the humans, they have to deal with cognitive bias. And this is, to me, one of the dangers of the video conference. One of the dangers, and I fully agree with all what you explained, but they need to realize that it's not so easy to make a decision, and that their brain is not working the same way when we are just looking at a screen. And if we are not very careful as defense lawyers to the habits of using technology every day, they will be like robots making decisions without realizing that they will not make the same decision if the guy was present. And today, in the French justice, you can easily understand that judges are looking for audience without people present, because the audience is something which needs time. And if we, as defense lawyers, are not very careful with teaching judges that they are not just clever people, completely free to decide what they want, and that they can be very, very influenced by their own brain, will have people never thinking about the importance of judging and the importance of be careful to law, but also to all the body language that you were speaking about. I'm really afraid about that, because yes, we can have many, many problems resolved by technology. It can be also lots of time that we will not lose, but we cannot use technology to judge everything without putting some money on the technology we use, because it cannot be just a cheap technology, but also we cannot decide to go to a video audience every day without realizing that it has a real impact on the way we decide.
Who is coming? It's okay. Yeah, no, it's.
I'm not sure if Alex Tinsley is over there, but also we have Ales. No, but you can come, Alex. And Aleš Michalevic from Belarus is going to participate online.
Connecting from Belarus, I want to make also an update on what is happening there in this third country. Maybe is he on Teams, Alex? No?
Yeah. No, but it's okay. So Alex We didn't have a chair, so I can share this. Alex knows that we are running a bit late, and so he's prepared to wait for a little bit. So I would just immediately give the floor to Alex Tinsley to talk about Brexit and the impact on judicial cooperation, and then we'll have I think that will be quite interesting. Our colleague will be speaking to us live from Belarus to give us an update on the current situation over there. Yeah.
I'll try to keep this brief because you had an update at the ECBA conference in Belfast just under a year ago from Edward Grange in London. And actually, when you look at the current position, although there's been some development, it's still the same binary question: is there going to be a deal or not? And no one's sure if there's going to be or not. This has all been hampered by the UK and EU trying to actually negotiate an international justice agreement by video link as well, and it doesn't look particularly good right now. Quick chronology, I don't want to spend too long doing this because you know all of this. 2017, we notify our intention to leave the EU. I say we, I don't really subscribe to the decision. But by the end of 2019, there's a UK-EU withdrawal agreement that provides for basically continuity of EU law for a transition period of 1 year, and potentially then some mutual recognition instruments to apply thereafter if the trigger event such as arrest on an EAW has happened within the transition period. Already though, at this stage, there are some departures from the existing scheme, constitutional protections on the extradition of own nationals, which were derogated from for the purposes of the European arrest warrant, now reapply because many member states are simply not in a position to create a derogation from that just for the purposes of the UK. So Germany, Austria and Slovenia are the countries that have exercised that option so far. At the same time as the withdrawal agreement, there was a political declaration stating the objective for a streamlined procedure on the surrender of suspected and convicted persons efficiently and expeditiously, basically trying to replicate something like the European arrest warrant, which is going to be the focus of this little intervention. Then we, in the UK, implemented that, and it was implemented on the EU side as well, just in time before the end of the negotiation period. Now begin the real negotiations, and it's been something of a fraught discussion. So the EU first defined its negotiation mandate, where it was looking at an extradition process much like the EAW, but with some further conditions. So political offence, which was absent from the European arrest warrant, nationality conditions, for the reasons I've just mentioned, are pretty much incontrovertible and so will be allowed again. Then the UK publishes its approach, and what it wanted was a separate agreement dedicated to justice and home affairs. No role for the CJEU, an absolute red line for the sovereignist kind of parliament of the moment, but then as much cooperation as possible in the key areas. And the ones I want to look at in particular are Schengen Information System and surrender. So what has been proposed on the EU side, and which the UK was interested in, was a surrender agreement based on the existing surrender agreement with Norway and Iceland. This is an agreement which took a long time to negotiate and took 10 years to put into effect, but it does exist, and it's a model that the UK was keen to adopt because it doesn't foresee any role for the CJEU, but offers cooperation on similar lines to the European arrest warrant. It reintroduces the option to have a refusal ground for political offences. I've noted that this isn't particularly theoretical anymore, as it was thought to be when the European arrest warrant was drafted. We've seen Assange, we've seen the Catalan cases. It's no longer something that can be considered theoretical and out of date. The nationality bar not an issue for the UK, but as I've mentioned, the EU states will need that. Framework list of offending, same as in the EAW. Trials in absentia, they've brought in provisions on the EAW which aren't in the Norway and Iceland deal, shouldn't be a problem. But then, interestingly, this agreement requires the UK, or would require the UK, to comply with certain procedural protections, such as the right to appoint a lawyer in the issuing state in an extradition case, supported by legal aid in the issuing state. These are all measures that are provided for in existing EU law, which the UK has opted out of to date under its current arrangements with the EU. And so, in a way, it would be having to go further than it currently has to. Of note, and this is potentially a big point for the purposes of whether something is agreed or not, what the EU has proposed is one global agreement covering all of the areas of the future relationship, of which justice is one area, whereas, as I mentioned before, what the UK wants is a dedicated treaty, and there may come a point where they have to decide if a deal is possible on everything, or if it's necessary to agree something narrower in order to preserve security arrangements. Next stage, in May of this year, the UK publishes its own version of the draft agreement. Political offence, no problem, but then it introduces two things: the proportionality bar, which is a proportionality refusal ground in UK law at the moment vis-à-vis European arrest warrants, which of course doesn't exist in the European arrest warrant framework decision, and another called the trial readiness bar, which is basically a refusal ground which enables the court to refuse extradition where it deems that the case is not sufficiently advanced in the issuing state to justify extradition. It is not part of the framework decision, and lots of people think that this is not compliant with the framework decision, despite the courts of the UK reading it down as much as possible to facilitate cooperation. So the UK is wanting to keep those protections in any future agreement with the EU. In June, the deadline passed for seeking an extension of the transitional period under the withdrawal agreement. So we're now into hot water because we need to agree something by the end of the year. Factoring in time for ratification on the EU side, it really looks like things need to be agreed in around October in order to be made good. Latest instalment, the EU has come back with another version of its proposed agreement. It doesn't cover the Schengen Information System, primarily because the European Commission has not yet decided whether or not the UK's data protection law can be considered adequate. It does envisage cooperation on criminal records, which is a first, I believe, for an external agreement. But still, these UK proposed grounds, proportionality and trial readiness, do not feature. So far the EU is not taking up that offer of the UK to include these things which the UK had unilaterally created in its national law. So the outlook as of today is either deal, a broader one or a specific one for justice, or no deal. And it looks like the issues that are really the sort of sticking points: ECHR compliance by the UK. We have judgments against us like all the others, but more broadly there has been a very concerted effort to, at least on a political level, indicate a departure from European human rights standards to create British human rights, which is a pretty bad sign, and there is a conditionality that is being pushed for by the EU, so that if we do leave the ECHR, for instance, cooperation would cease. These refusal grounds are likely to be an issue, and a very recent topic, the UK has started legislating directly against the existing withdrawal agreement in breach, according to the government, of its own international obligations, and this is likely to not facilitate negotiations in the next month or so, although it's probably intended to do exactly that. If we have a deal, things will progress much as they do at the moment, but if there is a deal, this issue around refusal grounds is going to be dealt with one way or the other. Either the UK will have to change its own law and bring it into line with what is currently the European arrest warrant, or the EU is going to agree an agreement which incorporates the EU grounds, both of which imply someone giving in. It's not clear what the outcome will be, and it seems difficult to preserve the current situation of deliberately fudging it and not confronting the compatibility issue when a new agreement is being reached. So something will have to give in that respect. Even if we agree a deal, it's not at all clear that this will include the Schengen Information System, and so we may have to fall back on bilateral transmission of arrest warrants and the Interpol system. If there's no deal, then we would immediately revert to the 1957 Council of Europe Convention on Extradition. All of the approach under Part 1 of our Extradition Act would cease to apply. This implies all the usual things to do with the old extradition system, a move back towards the government being involved, dual criminality across the board, delays because of the extra layers of process, and in the UK you need a domestic warrant to proceed to arrest the person, although there's new law being contemplated to deal with that. There is some provision for regulations which would enable the person arrested on an EAW before the 31st of December of this year to be treated as an EAW case thereafter, even if there were no EAW applicable between the two countries, because the withdrawal agreement foresees that. So an interesting day in court for everyone on the 1st of January 2021 for those people arrested around midnight. A final note on the Schengen Information System. In order to keep participating in this, the European Commission has to issue an adequacy decision, i.e. it has to have a look at the UK's data protection system and deem whether it provides essentially the same level of protection as the internal EU standards. Of course they should because of GDPR and so on. But there are serious problems. The UK and US have recently agreed data transfer agreements which are problematic. The UK was recently found to have been copying data on a mass scale from the Schengen Information System, which the European Parliament has been highly critical of. The European Data Protection Board has also just written to the Commission warning it that it is not comfortable with the UK's current practices. So there's nothing to be presumed there. If there is no adequacy decision, then there's a 3-month period where the UK retains access, but thereafter it's cut off from that database, and we'd be falling back on the Interpol Red Notice list as a way of identifying wanted persons and arresting them. If there's a surrender agreement, but we lose the Schengen Information System on the UK side, nothing much will change as to the extradition procedure, but something will change about the way we arrest people. And so that's pretty much where we are. The one thing I would say is that if we do end up with Interpol, it's at least a better system for the purposes of challenging alerts. So when you resist extradition successfully, you can then write directly to Interpol to challenge the alert, which is much harder to do vis-a-vis a Schengen Information System alert, because there the issuing state controls that alert 100%, whereas with Interpol it's centralized and it's determined according to autonomous rules, and it's a fairly user-friendly process. That is, however, the only silver lining in an otherwise highly worrying, needless act of self-harm in the area of security. So let's see what happens in the next month. Thanks very much.
Thank you, Alex. We're having some connection problems with Belarus. I hope everything is okay. He's online, okay. I hope he's not arrested. So it's going to work out, and we hope. I mean, for those of you who have not known Aleš before, he has been here also speaking at the last conference. He's also had some experiences in detention in the past in his own country due to his activities. And now recently he has returned to Belarus physically, so I think since a long time he had not been there. And we were very happy that he could just give us a short update from the ground on what is going on there. But we are having some connectivity issues. If you want to, if anyone has any question to Alex Tinsley, just a short one, while we are arranging the connection, please go ahead. No.
I think it depends partly on what happens at the end of the year. Sorry, that's a fudged answer. But at the moment, if they're arrested before the end of the transition period, it will carry on as a European arrest warrant case after the 31st. Query how lawful that is in some respects. If you're proceeding on without dual criminality when the actual basis has fallen away, it's a bit concerning, but the withdrawal agreement does provide for that, so it's probably safe. The question then whether an arrest warrant provides a sufficient basis to initiate a Council of Europe Convention extradition process is a different one, but it's likely to be dealt with by the fact that in order to proceed in the UK, the Secretary of State would have to issue a certified extradition request, and so they can figure out whether they treat them as an extradition request or not, although the issuing states themselves are expressing opinions on this, and my understanding is that Romania, for instance, is not at all happy about the idea of European arrest warrants being treated as extradition requests. So I think the answer is there's going to be a lot of chaos figuring out the answer to that when the time comes.
I think, yeah. We are not being able to connect with him. So what I suggest is that we just break for lunch and then we can check. No, he's not working. So I suggest we just break for lunch and then we'll see if he can talk to us either in the beginning of the afternoon or when we finish the working groups. Okay, yeah. Just a moment, just a moment. There is